Now we're on to what crime was he trying to conceal? And the first step in this is Bragg's understanding that he's not a federal prosecutor and doesn't have the jurisdiction to enforce federal election law. He tries to pin it on, he was trying to cover up, basically he violated a New York law. It's New York law section 17-152. And it goes as follows. It provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and then one of them acts on it, shall be guilty of conspiracy to promote or prevent an election. This is so ridiculous. I mean, everybody who's running for public office acts in concert with somebody else to promote or prevent the election of somebody. It's the unlawful means that this statute hangs its hat on. All right, well, what are you doing? Are you stealing ballots out of people's boxes? Oh, that would qualify. That's unlawful means. But this is, I don't know. That's the question. What is the unlawful means? And that's where we get to these three possibilities. It's like, what was that show we watched back in like the 70s where the doors would open? You have to pick door 1 or door 2 or door 3.
Let's make a deal.
Let's make a deal. Right. It's like, let's make a deal. Which door do we want? No, behind door number 1. It's a federal election law violation. Behind door number 2.
That would be great for summation. That would have been a great analogy for the defense summation. I'm dead serious.
Oh,
it would be great. They want you to pick a theory. Like this is let's make a deal, but it's not let's make a deal. It's somebody's life and somebody's liberty. It's not a game show. It's real life.
You tell us. You make them tell you. Which one? What did he violate? Specifically. So number 1 is, let's dispense of the other two first. Falsification of other business records and violation of tax laws. Here's what the jury got charged on tax laws. Under New York State and New York City law, it is unlawful to knowingly supply or submit materially false or fraudulent information in connection with any tax return. Same thing under federal law. And then they say, under these federal, state, and local laws, such conduct is unlawful even if it does not result in underpayment of taxes. So the theory is they doubled, this is the prosecution's theory. Cohen paid $130. They doubled that, $260, so that he could, and made it look like income, so that Cohen could actually get back $130. The Trump organization was out more money than it needed to be, right? If they had just submitted it as reimbursement because it paid the tax on all this money. And that was false. It wasn't, they didn't write down reimbursement and they didn't treat it for tax purposes on Michael Cohen's bills like a reimbursement. They treated it like a legal expense. And even though no one was hurt, the New York State Tax Department got more money than it otherwise would have. It's a crime to lie on that form. They ripped off the mattress tag, Mark. That's basically, they ripped it off.
You know, this feels like I just started teaching my law class again. And this feels like a law exam where you get points for every issue that you spot. He could have done it for this purpose. Oh, point there.
Yes.
Point. That's very creative. But then I would say, but just be mindful. In the real world, this wouldn't fly. And in this particular case, yeah, in theory, all these things might possibly have occurred, but weren't proven.
It's mattress tag territory, Arthur.
Can I ask you, I would like to ask you guys somewhat of a hypothetical here. If Trump was about to run for president and a construction company who Trump did not owe money to, so let's just say he didn't have sex with Stormy Daniels, he didn't owe money to, but this construction guy says to one of Trump's underlings, Trump owes me $100,000, and if he doesn't pay me the $100,000, I am going to tell the whole world that he's a deadbeat and you can't elect him president of the United States. And Trump says, fine, Michael, take care of it. And Michael Cohen stupidly takes out a home equity loan and takes that out for $100,000, and he pays him, and Trump gives him $200,000 back. And now they sign a general release, and there's no more, no one calling him a deadbeat while he runs for president. Is that a crime? Is that the same thing without the salaciousness?
Yeah, it's not a crime. Same as the Stormy thing. It's once again not a crime. I mean, a payment in settlement of a possible legal dispute is a settlement. It's like if the person's saying anything other than I might sue you, or then they're extorting him, right? Then they're committing the crime.
Oh,
right?
There's the word I've been dying to hear. I was on CNN last night with Stormy's lawyer, and I have no problem admitting to my two friends here, I didn't have the guts to use the word extortion. But one of the hosts did. He's like, well, what's extortion? And he's like, no, that's ridiculous. Nobody ever used the word extortion. And I'm thinking, definitely, it's just a sweet way of doing extortion. Well, I'll either sell it to the National Enquirer or I'll tell the whole world. So you can figure it out what you want to do. Well, I'm sorry, you can either pay me up or I'll just give it to the National Enquirer. I'll tell the whole world. It's only a form of extortion. No ifs, ands, or buts.
Yes.
Certainly you could argue that. And
there was a but.
Yeah.
What's the but?
All right, Glarish, I'm surprised you didn't get
that.
Oh,
there was a but. I'm sorry. I'm a little slow.
I was busy thinking about my next thought. Sorry.
Come on. That's your department, Mark.
Megyn, this show's getting more and more racy. I'm going to tell my mom not to watch.
Sorry. Yeah. I was thinking about my next point, which I should make. If someone had come to Arthur or me, and let's say there was some benefit in listing this as a campaign expense, I don't know that we would have signed off on it. But I don't know. Really, you paying Stormy Daniels? You're gonna put that on as a campaign expense? And let's say again, he really wanted to put that down as a campaign expense because there was some benefit to him. I don't know that I would say it's a campaign expense.
Wait, we're going to get to that. You're getting the cart before the horse, because right now we're on whether this is a violation of tax laws. This has been submitted to the jury, and they've been told, this is what they've been told, that if you put materially false or fraudulent information in connection with any tax return, that even if it didn't result in an underpayment of taxes, you've committed a crime. So that one's in front of them. The other one is falsification of other business records. And they list the bank records associated with Michael Cohen's account formation paperwork for the Resolution Consultants LLC and Essential Consultants LLC accounts. These are the ones through which he did the Stormy payments. The bank records associated with his wire to Keith Davidson, that's Stormy's lawyer, and a couple of other petty Annie shit. I don't even understand what they are, but they're small things that came in to evidence in connection with Michael Cohen's setting up of the payment system. All right, let's get to the big Megillah, the Federal Election Campaign Act. Here is what the jury was charged. Okay.
Drum roll.
I know, it's exciting. Under the Federal Election Campaign Act, or FECA, it is unlawful for an individual to willfully make a contribution to any candidate with respect to any election for federal office, including the office of president, which exceeds a certain limit. In 2015 and 2016, that limit was $2,700. It's also illegal for a corporation to do it. Okay. That's what they're telling the jury. Then they go on. The terms contribution and expenditure include anything of value, including any purchase, payment, loan, or advance made by any person for the purpose of influencing any election for federal office. Under federal law, a third party's payment of a candidate's expenses is deemed to be a contribution to the candidate unless the payment would have been made irrespective of the candidacy. The candidate's status as a candidate for federal office does not have to be the sole or only motivation for the third party's payment, so long as the payment would not have been made but for the candidate's status as a candidate for federal office. They seem to be offering a 51% more likely that it was to help Trump win the election and 49% for Melania's feelings possibility to the jury. Like, it's fine if there was a dual purpose, so long as you believe that if he weren't running for president, he actually wouldn't have cut the check. Melania's feelings didn't matter to him that much. That's how I interpret this instruction. And it's legally erroneous. Go ahead, Arthur.
The evidence that they're going to use, or at least they did use to some degree, was Stormy Daniels' feeling. Her testimony was, and they have her on tape somewhere saying, and other witnesses testified, we have to settle this case. I need to get my money before the election, because after the election, it doesn't matter. So if you believe what's in her mind was in Donald Trump's mind, then it's a problem for Donald Trump. If you believe, I don't need my wife hearing this, I don't need my brand, my Apprentice TV show, or anything else hearing about this, then I agree with Mark. If someone came into me and said, I want to make this payment and put it down as a campaign expense, I would have to really read that law and be like, I'm not sure about that because you'd be making this payment regardless. It's really
hold on that, because Michael Cohen also testified that Trump told him, allegedly, this seemed like an obvious lie, said to him, "Oh, I don't care if Melania leaves me. How long do you think I'll be on the market?" Sure, Jen. Sure, he did. Okay, but there's another piece that I didn't read. FECA's, this is part of the jury instructions, FECA's, federal election law, definition of contribution and expenditure do not include any cost incurred in covering or carrying a news story, commentary, or editorial by a magazine, periodical publication, or similar press entity, so long as such activity is a normal, legitimate press function. So if you, I don't know, had to pay a news organization, I'll pay $20,000 for your reporter to come out here and cover Mr. Trump, even though that would be ethically problematic as a journalist, they're saying that wouldn't be a campaign contribution. And the prosecution wanted more in there about what would be allowed and what wouldn't be allowed under the so-called press function. Anyway, the jury's been told that certain payments, certain contributions are allowed with respect to media, but it's not going to encompass what was done with AMI. Here's the problem with all of this. All of this is wrong. It's wrong. It's not a 51-49% analysis. It's not, so long as the payment would not have been made but for the candidate's status as a candidate for federal office. I mean, that's kind of it, but they've misstated it in a way that's too confusing. It's the nature of the payment. It's not what was in Donald Trump's head or Michael Cohen's head or anyone's head. It is the nature of the payment that determines whether it falls under federal campaign finance law. That's it. Is this the kind of payment that can ever be made outside of the electoral context? That's the question. That's how the jury charge should read. Do you owe back taxes? Pandemic relief is now over. Along with hiring thousands of new agents and field officers, the IRS has kicked off 2024 by sending over 5 million pay-up letters to those who have unfiled tax returns or balances owed. Don't waive your rights and speak with them on your own. Tax Network USA, a trusted tax relief firm, has saved over $1 billion in back taxes for their clients, and they can help you secure the best deal possible. Whether you owe $10,000 or $10 million, they can help you. Whether it's business or personal taxes, even if you have the means to pay or if you're on a fixed income, they can help finally resolve your tax burdens once and for all. Call 1-800-245-6000 for a private free consultation or visit tnusa.com/Megyn. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.